Happy New Year, guys.
Happy New Year.
Yes. It's 11:58 and we're filming.
Yes.
Not really.
We all just wore the same clothes as last week.
Merry Christmas and Happy New Year.
God forbid. All right. This is a good episode.
It will be, but before we get there, for everybody who
Yes.
enjoys what we do, you need to like, subscribe, and hit notifications so that you can support the work we're doing and help us continue giving you all this important information.
Mm-hmm.
And this is, we're going to talk about search and seizure. Liam's going to take the lead on this. But we've had comments come in from viewers who say they really enjoy learning more about the law. So it's going to be continuing education for our viewers. So we can help you learn more about the law. Mm-hmm. So search and seizure,
Why is this important?
why is this important? Like, why shouldn't the police just be able to search my car or my person or my house? Like, I got nothing to hide. Why do I care?
Well, yeah, famous last words until the police find all that incriminating evidence. The reason that you should care, Joe, and I know that you do care, given that you're
I'm being facetious.
a devoted advocate for the defense. The reason you should care is because, at least here and in other places, it's constitutionally protected. You have a constitutional right to be free from unreasonable search and seizure.
And we're going to give some real examples at the end.
In Canada, that's protected by Section 8 of the Canadian Charter of Rights and Freedoms. In other places, for instance,
Which has a Section 1.
Yes, that's true.
We'll get to
although,
that too.
with respect to
I hate Section 1.
Section 1, it makes sense, but that's for another podcast.
We'll explain this.
We're talking about search and seizure first. Yeah.
In the States, it's Fourth Amendment jurisprudence is how it's often discussed. And then in the UK does not have a
Charter
written
or constitution.
Yeah. Well, they have a constitution,
Of kind.
of a sort.
Yeah.
But as I understand it, a lot of the your rights against search and seizure in the UK are contained in what's called the PACE Act, which is Police and Criminal Evidence, I think. I might be wrong about that, but it's definitely PACE.
But in Canada, there is Section 8 of our charter that prevents the police from searching your home, your person, or any place where you have a privacy interest unless they have grounds for it. And you need to explain the difference between why we have this term unreasonable, explain what a search is, what a seizure is, what is unreasonable, and how does this flow?
We talked about this earlier, and you broke it. You laid it out, I think, really well. Where you're saying there's three aspects that you need to look at. One is what is a search, what is a seizure, and what is unreasonable.
Okay, so the wording of Section 8 states that everyone has the right to be free from unreasonable search and seizure, as Diana has just helpfully introduced. So let's start with searching. Okay, it's what it sounds like. So normally the police cannot show up at your door, force themselves inside, and start turning out your cabinets. They can't do that.
You can't storm your house.
No, they very much can't do that.
Or your car.
But far be it from just the house. A house is sort of the prototypical.
And it's also the most sacred of property privacy rights we have. Traditionally in North America and the UK, your home is your castle. And it's
I was going to say, your home is your castle.
Where you have the highest privacy interest.
And it's in a lot of cases that involve sort of people or the police coming into private spaces. You can tell that it's a really sacred right when they start breaking out quotes from William Pitt the Elder in 1690. It's like, oh, the King of England cannot enter. No, the wind may enter, the lightning may enter, but the king cannot. That kind of thing. That's come up in more than one Supreme Court case, that exact quote.
I can say I have not used that.
I got to say that I love when the courts quote Monty Python.
That's more effective.
It does happen quite often, actually.
So, but let's go beyond just your house.
Right.
In Canada, the police can't just stop you on the street and frisk you. Stop and frisk is unconstitutional in Canada.
Okay, so let's pause there for 1 second so that people understand. Yeah, so you're walking down the street and the police can't just stop you and search you.
No.
Because you look suspicious.
Well,
based on
depends.
what? Based
it
on
depends.
Yeah.
We all knew what the carding
There are
issues
things
were.
like plain sight, right?
No, we're just talking about somebody walking down the street. So plain sight is actually, that's why I said it's not always that clear. If they look into a car and they see a gun sitting on a seat with a bag of marijuana, they can seize it because it's plain sight, they see it. But let's start with something basic because people ask these questions. You're walking down the street. Can the police stop you? Well, they can stop and try and talk to you.
Yeah, they're allowed to try and talk to you. You don't have to talk to them, though.
And do you have to give them your name?
Generally, no.
Okay.
Generally, no. If you're under arrest, then yes. If you're driving, yes. But generally speaking, if you're just walking down the street, it's like, hi there, sir. Can you provide me with some ID and let me know what you're doing in the area? You can say, no.
I'll give you a donut.
And keep walking. I don't want to aggravate
So that's
them.
important.
Well, we know cops like donuts.
Is there a basis in which you could be detained while walking down the street? And what do the police have to have in order to do that and then to eventually try and arrest you?
Well, and correct me if I'm wrong here, but essentially they need to have reasonable and probable grounds to think that you've committed an offense.
Right.
In the circumstances, in which case they're allowed to detain you. In certain other cases, they're allowed to do what's called an investigative detention, which is not an arrest. You haven't been charged. There are some very
This
limited...
is so technical. I'm sorry.
Yes, exactly.
So I just want to get you to use like normal language.
Okay, so it's...
It's hard to do.
Yeah, well, no, and I mean, again, that demonstrates why we have jobs. But...
Which I'd like to maintain.
Yeah, everyone stop watching. Don't stop watching, please. Subscribe. But...
And hit notifications.
But no, generally speaking, police cannot just stop you and start searching you. And there's different degrees of privacy in different places. So it depends on where you are. If you're, for instance, a high school student and you have a locker, you have some privacy there. You don't have that much privacy there. You certainly don't have as much privacy in your high school locker as you do your home. You don't have as much privacy in your backpack as you do your home, but you still have these privacy rights, which the police, generally speaking, unless it's a certain circumstance which makes getting a warrant impracticable, they cannot just start going through your stuff.
So let's just break down a couple examples for fun. So let's say the police...
Well, I just want to actually, because something crossed my mind, and I'm asking this because I don't actually know the answer to it.
Okay. Cool.
So you were saying you don't have to give them your name. What happens if you give the wrong name?
That's a good point. Excellent question.
That's bad.
That's
Don't
bad.
give the wrong name. Don't lie to a police officer.
It can be public mischief, or if you're
Obstruction of justice?
maybe, impersonation. So let's give an example. Police are called, they're dispatched to a stabbing, and the person's described as being 5'10", a reddish beard, a Caucasian male, running down the street with a knife that has blood on it.
Do you really think that I'm 5'10", Joe, and that my beard's red?
It's reddish.
It is reddish.
Okay, I'll
Yeah.
accept
Are you at 6 foot?
Yeah, that's what I put on my dating profile as well. I
Oh,
was still
so
on
sorry. Okay. But, police arrive quickly on scene. They see somebody matching description running down the street with a knife in their hand with blood dripping from it. Well, they have grounds to certainly detain and arrest that individual. So these are all degrees of what the police may observe, what information they may have to show that they have reasonable grounds to stop somebody and detain them. And
I actually
arrest
remember
them.
when I was a teenager.
You ran down the street with a blade?
No, I didn't have a bloody knife or anything like that, but I was walking with somebody and the guy I was with matched the description of somebody they were looking for, and they actually pulled over and asked us a few questions and so on. They were quite polite.
Yeah, on those types of situations, you may find that, it's not invasive at all.
We're just like,
They're
we're going, what
asking
happened? What
questions,
happened?
yeah.
And it was clear from your reaction. It was just like, I don't know.
But, so you raise a good example. There's different degrees of privacy, whether it's your home, your car, if you're in school, your locker or your backpack. And there's degrees of privacy and degrees of information that police may have that may allow them to conduct a search. Let's throw another technical term in here for 1 second: exigent circumstances.
Exigent circumstances. Okay, so
Break it down into some English.
I've never even heard this phrase. This is cool.
Emergency circumstances.
So let's say the police are out minding their own business, walking down the street, beat, that kind of thing. They see an individual with let's say a freezer bag that's full of what appears to be cocaine.
Severed heads? Oh.
Well, no. It matters that it's cocaine here, okay?
Okay.
It's not Halloween.
Like a freezer bag, like pretty
Been
full
watching too much Netflix. Sorry.
of what appears to be cocaine. That's a fairly large amount of cocaine, a trafficking quantity.
So
of
it's
cocaine.
like a giant Glad bag that you can see through and it looks like cocaine.
Yeah. They see the individual with this large freezer bag go into a house or go towards a house, and then the police say, "Stop, police." The individual runs into the house, closes the door. In those circumstances, the police have a reason to believe that someone is about to destroy some evidence of a crime. Because, well, yeah, that's probably thousands of dollars worth of cocaine in that bag.
It sounds like a real case you're talking about.
No, this is just something off the top
Just
of
off
my
the top
head.
of your head.
Make an obvious example.
Because everybody who deals cocaine walks around with a clear freezer bag.
Not the successful ones.
Yeah. But that can...
There's a lot of like, what do they call that? Like the awards that they give out for idiots.
Yeah, the Darwin Awards.
Darwin Awards.
That's only if you manage to kill yourself. But like that, all that cocaine can go down the toilet in minutes. There is not enough time to go before a justice and get a warrant. There isn't even enough time to call a justice and get a warrant. So in those circumstances, yes, there would be a charter application about it. You're going to argue about it. But in that case, I would think that the police are likely going to be found to have acted reasonably in those circumstances.
Actually, there's a real case that I read where there was a domestic violence situation going on, and there was lots of evidence that this woman in the home was being severely beaten. Mm-hmm. And when the police came in, the guy took off down the stairway and went down to the basement. So they broke their way into the basement, followed him down, and they found a whole bunch of evidence of other crimes. And that was deemed to be an appropriate pursuit because they were, they had reason to believe this guy had committed a crime.
They're in hot pursuit of an individual that they have reasonable grounds to believe has been involved in a crime. So you can have a number of reasons to have what's called a warrantless entry into a home or another location where you have a privacy interest. And that could be to prevent the destruction of evidence, for protection of an individual who you believe is being assaulted or harmed or could be killed. And so for life and protection and any other circumstances?
The only other one that comes to mind off the top of my head is officer safety. If you have a reason to believe that there's an individual in that house and there's a vantage point and they have a firearm or something and they're going to start taking shots at officers, in that case, yes, you're allowed to go in.
Otherwise, to search a person's home or car or maybe phone, which is seized, they need a what?
A search warrant.
A search
Or
warrant.
a prior judicial authorization.
And how does a police officer obtain a search warrant?
Again, the operative word there is judicial. So, if we go all the way back to Hunter and Sutham.
Oh, don't do that to our viewers.
Don't do that to our viewers? Okay then. Well,
or me.
As much as I love the combined
let's talk about the word
Investigation
information, because I think it's one of these terms. It's like you don't expect. It's like somebody swears an information or lays an information or an information to obtain.
Okay, yeah. So let's explain this.
We're gonna get there. So a search warrant is essentially it's a court document giving the police lawful authority to enter into a place and search it.
By order of a judge.
Not necessarily by order of a judge. It depends.
Could be a justice of the peace.
Depends on the kind of warrant, but
it's a judicial officer, so you can have.
It's not just the police saying, "Hey, I agree with myself."
Yes. So let's break it down. So the police could go before, let's say it's searching a home. They could go before a judge and seek authorization for a warrant to search a house, or if they want to, for example, search bank accounts. They would get something called a production order, very similar to
the
a warrant.
Emergency Act.
We've covered that one. And in order to do that, Diana, you raised a good issue. What's an information to obtain? What do the police have to say to this judicial officer or provide them with in order to try and get that warrant?
Diana raised an interesting point in terms of just the way that we use words, such as a capital I information. Now, just your information simpliciter is, just an information.
We'll teach you how to speak English soon, okay?
I'm relearning. Law school did this to me. So just a plain old information is a charging document. The police lay in information against Liam Thompson saying that he did commit assault against Mr. Smith on or about the 20th day of December.
That's a charging document.
That's a charging document. An information to obtain is a little bit different. An information to obtain is a sworn statement by a police officer, effectively setting out three things: that they have
reason to believe.
Where they have reason to believe that a certain offense has been committed. They have reason to believe that certain evidence of that offense will be found in this place. And then they essentially set out in a pretty minuscule detail, depending on the case.
Some better than others.
Yes, some better than others.
And that's what the difference between a strong warrant and a weak warrant, and how we can attack warrants.
Yeah.
But in a lot of cases, as you're saying, this information to obtain, which is basically a story from a police officer, can be very detailed and can be based on evidence other than what the officer knows he or herself personally, but can be from other officers that he believes to be true.
And the judge
that.
will assume essentially that what the officer is saying in their information is correct.
Yeah, but a judge or a justice of the peace can ask questions and can be skeptical if there are certain issues that they don't feel is borne out appropriately in the information.
And then if they can deny it, they can send the police back to re-prepare a new information to obtain. Those are all options. But the big point is that the police need to go forward. They need to make very full and frank disclosure, because when you're going to get a search warrant, I'm not just going to say it's ex parte, but it's when the police are the only ones in front of that judge.
You just said ex parte, so explain.
Exactly.
Again, because people asked us these questions, so this is why we're answering them.
Yeah. So ex parte essentially means that only one person is there to make their pitch to the judge.
There's no defense.
No.
Right, so the person who's about to have their home searched by police have no notice that this is going to happen, and there's good reason for that.
Yeah, quite often there's good reason.
There's good reason for that, but they are not there under any type of representation or personally. So there's a higher level of scrutiny that a judicial officer has to apply to reviewing the information from a police officer to ensure that there are sufficient grounds to give the authority to go into somebody's home.
Which is, again,
or to crack open their cell phone.
It's a big deal.
And you got to note, too, the manner of entry into the home is dependent on the level of risk that's assessed in advance. So there's a knock policy that can be overridden.
Let's do one thing. So warrants will also be laid out as to when it is going to be in effect. So you could say it's available January 1st between 9 a.m. and 9 p.m.
Generally speaking, you're not supposed to execute a warrant at night unless it specifically says that you are allowed to execute the warrant at night.
There has to be a time frame.
Yeah.
And then they can allow these time frames depending upon what the reasons are. Then they can also allow warrants where it's what they call dynamic entry. In other words, it's not a knock warrant. In other words, they go up to the door and they go...
break it in.
They go up to the door normally and go, hello, hi, police constable Roy here. We have a warrant to search the home. Open the door. Hi, officer. Yes, we have a warrant. Do the police have to show the warrant?
Yeah, they're required by Section 29 of the code.
What code?
Criminal code.
Ah, good. Thank you.
Even if they break the door in?
Well, no. What
they still have to have the warrant with them.
Yeah, they have to have the warrant with them. Can't leave it at the station. But you're generally required to, let's assume that this is not a warrant that authorizes a dynamic entry. The general practice is that you'll need to, knock, police, we have a search warrant, give a reasonable amount of time, and then if no answer, then they're allowed to break the door down.
Okay, so let's say, this is not a dynamic entry, which is kind of a sexy term. It means you're allowed to enter without forewarning because you believe some shit's going on in there, that if you give them notice...
I was trying to remember what the Scarface scene was, where he's just like, say hello to my little friend.
Those weren't the police that were coming in.
Okay.
Those were his competitors, okay? He had pissed off his competitors. But so So a dynamic entry is because they don't give notice. They just kick in the door and go in, usually with armed officers, because they think some bad will go on if they give notice. This is not that type of case. So they knock on the door. Somebody opens it up. What rights does that person actually have when they're faced with 3 officers or 4 officers at the door?
Outside the door still.
Outside the door. Can they say, no, you can't come in?
I mean, you can say that.
But
I don't think it's going to go well for you.
Right. So they can force entry then.
Yes.
And then they will detain you.
But the warrants actually say specifically what they're permitted to search for.
Yeah.
Like, it sets out what they expect to find in a place. If they find, like, other stuff, like, say we have a warrant to try and find a gun. Okay. If they're there, they don't find the gun, but they do find, like, cocaine or a detailed manuscript describing a murder committed with just this gun. This was the serial number. It was a great time. Signed, Mr. Accused. Then yeah, they can seize that as well.
Other items that may be illegal that are in plain view during the course of a search, so where they can see it, they can seize. But they're not supposed to go beyond the scope of what they're specifically investigating. So if they're investigating documents that support a fraudulent transaction, they shouldn't be seizing other items that are unrelated to that investigation. Even if it seems a bit odd, they shouldn't be doing it. They should be restricting it to computers, financial records, that type of stuff that's laid out to the warrant.
That said, if they are searching your computer for fraud, and then they find
child pornography,
they can take your entire computer. So it's a good reason to have
Yeah, but hold on. But hold on. If they find child pornography on the computer when they're searching for financial records, they will need another warrant. They can seize it, and then they should seek another warrant to do another search to bring out that information, and that is a protection for the person. But that means they can seize the computer that has that illegal information on it.
So there's 2 cases that we specifically were looking at over the last year.
Can I just stop for 1 sec? Because people were asking really for the basics, and I just want to cover this one thing. So the police get in now to the house because you have to let them in. The person who's in the house, are they allowed to roam around?
Generally speaking, no. You won't necessarily be, like, locked up, but you'll, at least from what I've read, the officers will stay with you and essentially make sure you're not destroying any evidence.
Right. So what will happen is the person will be detained. They'll be put down on a couch or a chair. One officer will be detailed to stay there. Maybe talk to you about football or how the Raptors aren't really scoring right now.
I know, it's terrible.
But you will not be able to call a lawyer at that point. Because they can't allow you to make phone calls because you could be alerting somebody else to something that could be relevant to the investigation. They can allow you at a certain point in time to contact the lawyer, but they don't have to. So for the duration of a search, they can be detained there for some period of time.
Yeah.
Just so people understand that. So if this unfortunately happens to an individual, they're detained, they're going to have to sit, let the police do what they do, and then they'll have their chance to speak to a lawyer and deal with it. Now you want to raise a point about some examples. So
I have 2 examples of cases that I found really interesting over the last year. One of them, the charge was ultimately withdrawn, and this individual was essentially guilty by association. They were investigating a different person, and I don't understand why people are gun enthusiasts. Sorry to all my U.S. fans who love their guns.
Yeah, we're going to get some calls.
But yeah, I know. But he happened to be a member at the same gun club, and as a result, they became friends. And he was seen going out for lunch with the guy. They had nothing more than that, except for it was basically, in this case, it was guilty of being black. I'm going to say,
that's what we have to look for. Bless
because
you,
yeah, but it was actually really.
Hi, Marcy.
It was a really sad case, for me to, I was going through the things and just trying to log in what the disclosure was, because there was a number of other people under investigation and he got kind of caught up in the mix of it. But there was very little to connect him to the actual target of their investigation. And what made me upset was watching that there were these 2 preteen, kids he was their older brother, who were sitting there in the pictures and the videos and so on of the search being conducted. And of course they found guns, but they were all properly registered and everything. But they were just sitting there on their phones like nothing was going on. Their entire glass door from their kitchen was shattered when the police entered. And they searched every room. They searched the teenage girls' rooms and everything. And it was, to me, it was so sad to see not just that it happened, because it shouldn't have, and in the end they realized that they didn't have justification for this warrant based on the very minimal evidence that they'd seen, but that these kids actually didn't even find it surprising. They were just chilled out playing on their phones while the police searched their house.
And sadly, these things happen. But, in
this
Canada...
this is an example, though, of why it's important that these warrants are obtained properly.
Yeah, I mean, in Canada, again, people will debate with me about this, but we've done our fair share of search and seizure cases. The majority of warrants that I've gone through, police generally do a fairly decent job of laying out information. But where we've had a lot of problems in Canada and the United States, but more so in Canada, which we can speak to, is where it's based on false information, where we've always had this cloak about confidential informants and confidential informants not existing, and then evidence which really is made up and not supported, and there it's ripe for abuse. And we're not saying that it happens all the time, but it does happen. And I've had a couple of drug cases where it was pretty clear that the police had strong suspicions, but they didn't have the evidence to back it up, and some evidence couldn't be established. And one thing that we're getting a bit technical, but people can understand, is you have the warrant, and then underneath the warrant you have the supporting information that the police provide. So there's what we call facial validity to a warrant and subfacial validity. And what we mean by that is once you look at the information below it, a police may say, I spoke to Constable Stern. Constable Stern surveilled this suspect whose house we're going to and watched him go for a location A, B, C, and D, and had done various things which was indicative of drug trafficking. And then as a lawyer, you write for the notes of Officer Stern and the notes of the officer who is the informant on it to establish where the did he get this information from, what did this officer actually observe, was there any video or pictures taken when they were doing surveillance on them, and surprise, surprise, you get notes that are very thin or no notes, or then you start to ask, well, if you had him under surveillance, because we've all had strong cases where, for God's sakes, there's literally videos, like giant videos and pictures of the clients, everything, right? Yeah. But then when you see cases where they're not able to substantiate the information that's below what the officer is saying, that's where you start to dig and find that there's falsity. And that's why it's very important that there is this very rigorous standard for judges to apply to a officer's information in order to justify a search, because it's very invasive. And these are important factors, and this is where we'll roll into people saying, well, they're guilty, they just got off on a technicality. No, searching your home, searching your phone, searching your car, going through your bank accounts is a very serious thing.
Now, on that note, in terms of just getting off on a technicality, I want to... This is something that Diana sort of touched on a little bit earlier by reference to Section 1. But the operative section, when we're talking about search and seizure and illegally seized evidence...
Yeah, this is a good
what's
point.
Section 1, though?
Forget about Section 1 for a moment, because Liam's going to give you a section that'll drive people crazy, okay? Section 24.2.
Drives me
nuts. I know. It's actually worse.
Because I think maybe you were thinking about this, too, also, with search and seizure. Because
So, Section 24.2 of the Charter states that where evidence has been obtained in a manner that could bring the administration of justice into disrepute, then it may be excluded by...
So the court has already found... So just to explain, because again, we've had questions, and thank our viewers for asking questions, but so when there has been, let's say, an illegal search of a house, we've discovered that the basis in which the warrant was issued is deficient. So there was a violation of the person's Section 8 rights. They did not have sufficient grounds to enter the house. That said, they seized cocaine and a gun. Okay?
Make it fentanyl.
Fentanyl. Even better. Cocaine, fentanyl, and a gun.
Yeah.
And the judge has already found that there is a violation of that person's Section 8 rights, and there may have been, let's say, a violation of Section 7. We won't get into it now. Then we move to another section of our charter called 24.2, which is an analysis, because in Canada, if you find a breach of the rights, that does not mean automatically that the evidence is excluded.
It means it's time to call a lawyer if you don't already have one.
Right, but this is an important point because not everybody understands this. They think that if a
They
right
can
was
override
breached,
your rights.
yeah, because our rights in Canada are fundamental freedoms, but they are not absolute rights.
Right.
So the 24-2 analysis is this provision that's been revamped in new case law over the last decade, where you go through a certain analysis to determine, regardless of the breach, should this evidence be excluded? Or would its exclusion bring the administration of justice into disrepute? And this is very malleable, and it's very hard to give any definitive answer. And it's something people should understand in Canada, that rights are not absolute. You can have your rights breached, but because of the nature of the evidence itself may still be admitted to a trial and somebody convicted.
And I mean, it all does depend. Like, there's three things that you need to consider in a 24-2 analysis.
Yeah, and do it slow.
Okay.
And as English as possible.
As English as possible. Okay, so first, how badly were your rights violated?
Good.
Is this the police just thinking, like, this guy seems like a bad guy, I think we're going to break in his door and see what's up? That's a pretty flagrant breach of your Section 8 right. 2, what is the seriousness of the charter infringing state conduct? So in English, essentially, how bad were the police acting, and how bad did they know that they were acting? Was this a complete disregard for charter rights, or is this an instance where the police,
How unreasonable was it? I think is where
They're acting on good faith.
Yeah.
They think they're doing it correctly, but they're making mistakes.
Yeah,
or are they knowing that they're f***ing you over, right?
That's and I mean that one
That's
has
a very technical legal term.
a fair bit of nuance to it, but again,
F***ing you over?
yes.
Yeah, okay.
Yes, that's the gist of it. And then finally, my least favorite part of the analysis,
Explain this slowly.
the society's interest in trial on the merits. So, what that means is...
I'm glad we're doing this,
Yeah.
This-
So,
It's good to talk about.
the court knows that our hypothetical accused had a gun, had fentanyl, had cocaine. What is going to do the perception of our justice system more harm? Is it going to hurt the justice system more if we throw this evidence out? Or is it going to hurt the justice system more if we keep it in?
Yeah, good.
And you consider a whole bunch of...
And how will it affect other people's rights, I think, is one of the issues as well, right? It's not just, maybe I'm wrong about this, but if we allow this to happen to this one individual, what would that mean for other individuals?
Well, it's always like a very flexible analysis.
As I always say, other people's rights are your rights.
No, it's true, and this is why this is important. That's exactly why I talk about why criminal trials are the crucible of a democracy, because this is how we protect our rights. And regardless of whether this person may in fact have been guilty of the offense, and again, there's no such thing in my opinion as a qualified acquittal, leaving that aside, it is very important for all of our democratic freedoms that when the police do not have the proper grounds and they flagrantly breach multiple rights of an accused, that it's those cases that evidence should be excluded and a person should be found not guilty, because to authorize bad conduct is to only encourage it.
And I mean, to touch on a slightly troubling trend in the case law over a couple of years, it's what some defense lawyers call a 24-3 analysis. And the joke there is that Section 24 only has two subsections, 1 and 2. The hypothetical Section 24-3 is, if it's a gun, it goes in.
And in the older days, we used to have real evidence versus other types of evidence. So real evidence was referred to something that's...
Something you can hold.
Something you can hold. So a gun, fentanyl. If it's real evidence, how can its exclusion really impair the fairness of a trial? Because it's bad stuff. It's got to be excluded.
As opposed to...
a statement.
Officer Neuberger arrests me and then immediately asks
That's his day
me,
job.
Did you do it? Did you do it, Mr. Thompson?
Of course I did it.
That is a statement obtained contrary to section your rights to counsel, as we discussed the other day. And that will more, even today, that a statement that is obtained contrary to the charter is presumptively inadmissible. So the Crown has a lot more work to do if they want to get an unconstitutionally obtained statement into evidence.
But this was the old distinction, just 1 second, between what was real, tangible evidence of something that you know is nefarious, like a gun or drugs, as opposed to something that would emanate from the person's body. Could include a DNA sample, could include a breath sample, could include a statement. That delineation was taken away, but it's still there.
So, but you're talking about solid evidence, and so that reminds me of the other case I wanted to mention, which is kind of interesting, that there was real evidence obtained from a storage unit of basically a meth lab, and all of it ended up being excluded because the only basis for the warrant to search that storage unit was a single person who phoned the police with a tip, saying that they were in a position of knowledge. And this was a person who had never given a tip to the police before that had panned out, so they had no reason to say this is a trusted source. And so then we have all this solid evidence that ended up, and I think was a really important decision, because you brought this up, because we were talking about it earlier, you brought up swatting.
Yeah.
And this is a very similar kind of scenario where you have police taking action based on a tip from a single source that's unknown to them.
Let's talk about two examples, because I think this is really good. You raised an interesting point. So a long time ago, I had a case where it was literally information from a confidential source who had dealt with my client and was allegedly reliable to the police. The police had done nothing to verify the information that was provided. So generally, so people understand, when the police have a reliable source, they'll say, I'm dealing with Mr. or Miss X. This is what they look like. This is the location. This is what I've done with them. This is the illegal activity.
They've given us a number of tips.
And then the officer will say, this individual has given us information in other cases that has proven to be reliable. Okay. But the police are supposed to do something more than that. There's supposed to be some independent investigation to try and verify. And in some instances, it's really quite silly. You take the name, you run it through the data system. That's the name of the person. They match the description. That's the address that they have. That address is legally registered to them. Is that enough? It shouldn't be. There should be some surveillance of the location. So I've had cases where, in fact, what was done to try and verify the information of this allegedly viable source, who you never really know because they're confidential, could be bullshit, nothing was done. And then evidence gets excluded, even if it is real evidence.
It's so important, because otherwise anybody can call up the police, say anything they want about anybody they want to take revenge on for whatever reason, and have their entire home invaded and have
You've just taken
turned
this
their life
in an excellent direction.
upside down.
Brilliant comment. Think about the abuses. And this is when people say, like, we excluded, drugs or something else. That's ridiculous. They go off on a technicality. Just think about it. If we don't check the sources, and I'm mad at you for whatever reason, I can call up and make a fairly informed description of get your rights invaded. They may find something that has nothing to do with what they're there for, and you're over. And that's why these things have to be scrutinized.
I mean, it's interesting, and I don't know if this is like a little bit too off topic, but in Canada, a private citizen can actually lay a criminal charge. It's more difficult than if you're a police officer and you want to do it.
That's a good point.
But a private citizen
They usually don't go well.
can commence a criminal charge. But a private citizen cannot just obtain a search warrant. Right. You can't lay you can lay a private information, you cannot lay a private information to obtain and start invading people's privacy like that.
Yeah, and there's more to it. God, this must be 15 or 20 years ago. There's a case that we did out of the Court of Appeal where, we had clients driving from British Columbia to Quebec through Thunder Bay, which is, the Trans-Canada Highway, and it's notorious for drug interdiction, right? And these two guys are driving in a Cadillac, and the back seems to be a little low. And the officers, who actually we got kind of friendly with afterward, but they honestly said, well, they look really suspicious. They look Latin. So we pulled them over. And then they started to ask them questions. And then they started to search the vehicle because they thought they had grounds, because they thought they saw something in the car. And there's a whole host of violations. Like, when you're pulled over, they want to search. They have to ask if you can search. And in order to search, they have to give you rights to counsel. And you have to have a right to call somebody first. Like, there's multiple violations along the way here, which at a certain point, Oh yeah, and then they pulled him over for speeding, and this was the best. I'll never forget. God, I love this career. So the officer said he pulled him over for speeding. I'm looking at your notes. It was 7 kilometers over the speed limit. And he looks directly at me and goes, "Speeding is speeding, Mr. Neuberger." And I said, "That's not speeding, officer." And actually the car had Quebec plates, and I don't think there are speed limits in Quebec. But anyways, it was just funny.
The stop sign is just a suggestion.
But
what
got good about that case was the officers stopped justifying their situation and just went with it because they knew they had done this. And it became a well-known case, which is a standard now for ensuring that you get rights to counsel when when you're asked if they can consent to search the car, et cetera, et cetera. But it's a perfect example if you think you're driving across the country and you look Latino, or you look dark, or you look too Jewish, or you look too whatever, you look too happy. They pull you over and they're searching your car. Next thing you know, you're on charges. And so these are real examples of stuff that we have to be careful about.
If you're happy and you know it, it's your meds.
I think we'll end on that one.
Yeah.
Well, if you have, so like, subscribe, share, whatever. But if you have more questions about this, because this emanated from, I think, two viewers who had some comments and then some emails saying, we'd like to learn a little bit more about the law. So that's a lot of fun because we don't go back through the basics as much as we'd like to sometimes. And it brings you
I'm
back
sure
to
we're going to have a
stuff.
bunch of questions on this one to explain some of the that he said. To tell you the truth.
Ex parte.
Sorry.
But it was fun. So thank you very much for viewing. And again,
cheers.
Happy New Year. Healthy and happy 2023. Cheer, guys.
All right. You guys are all empty.
Less Latin.
Did you just chug all that? Liam.